today, we will be going through the schedules, starting on page 61. In terms of the carryover items, the technical team has asked for some more time. Thank you, Member Gale. We'll move to confirmation of the minutes of the meeting held on Thursday, January 26, 2023. We'll begin with page 1. We'll move on to page 2. Page 3. Page 4. Page 5. Page 6.
Chair.
Please go ahead.
Clause 58. The second line, it says it addressed the serving, it should be serving of notice and not serve of notice.
Serving of notice.
And under subclause 59.3 to 59.5, the second line, 59.4, there was a decision, the word "a" to be inserted. And in the third line, subclause 59.3, to treat with employment arrangements. So the word "with" to be inserted and "employer" to be deleted.
Treat with employer arrangements.
Employment.
Employment, or delete employer.
And if you go down, the tenth line in that paragraph, which speaks to the fine of $50, says which should be reviewed. I want the record to indicate that I did indicate that it's currently been reviewed under the Education Regulations Review. It should read which is currently being reviewed under the review of the Education Regulations.
Thank you. Page 7. Page 8. Page 9. page 10. Page 11. All right. I now ask for confirmation of the minutes held on Thursday, minutes of the meeting held on Thursday, January 26, 2023.
I so move, Chair.
Moved by member.
Second, so move to second.
All right, thank you. Are there any matters arising from the minutes?
Chair, I wouldn't say directly from the minutes, but I want to seek some clarity in clause 51. That speaks to referral of complaint or report, and it's under the caption powers of investigation. Now, 51.1 states, upon receipt of a complaint under section 50, the council shall, based on the circumstances and particulars of the complaint, and I'm reading from the last report submitted. It says, A, refer the complaint to the ministry with responsibility for education for investigation, and B, refer the complaint to the board of the relevant educational institution or any other employer of the licensed teacher or instructor, as the case may be, again for investigation. Or C, refer the complaint to the Professional Practice and Conduct Committee of the Council for Inquiry. No. Sorry. No. Reading from the wrong one? No, you read the correct one. You changed it today? Hold on. It was changed last week?
Yeah. Remember, Chair, if I may, through you, it was changed, the new reading was changed from last week to indicate specifically the removal of the referral to the ministry or minister. So we did make that change. So this section says, A, refer the complaint to the Professional Practice and Conduct Committee for consideration to determine whether, 1, the complaint should be referred to an independent investigator appointed by the council for an investigation, or 2, to conduct an inquiry into the complaint. So that was a change that I read in the last sitting.
Thank you.
All right, thank you so much. All right, for today, we will move on to the schedules. The technical team has asked for some more time to consider the comments that came back from the SG's office with regards to the items discussed last week, and that had to do with the disciplinary process. All right, so we'll move on to the first schedule. And the first schedule has to do with the constitution of the board. And there are several recommendations, starting with the Ecumenical Education Committee and the Jamaica Council of Churches. So the following are being proposed for the composition of the board in the first schedule. Because of the large proportion of schools, the owners of denominational schools should have 4 members on the board. They reject the notion that one of them should be a licensed teacher. As significant owners, the trust should have 2 members on the board. So let's go to the schedule. I wonder if it would make sense, Ms. Anastasia, given that you've already compiled, based on the recommendations, what it would look like. I don't know if it'd be easier to do it that way. Okay, maybe we should copy this. We should copy this for each member to look at. Members will circulate copies with the proposed changes. I think it'll be easier for us to go through than for me to try to read everything. Go ahead, member.
Thanks, Chair. So based on the proposals to be made in terms of Schedule 1, first schedule, for 1D, the first change was made to 1D. The proposal is to change 6 registered teachers nominated by an association recognized by the minister as representing the majority of teachers in Jamaica, 4 of whom shall be licensed to practice as a teacher under this act. So we have reduced 5 to 4. And that is when you get the fulsome change, you can appreciate the overall changes.
Madam
So I
Chair.
can indicate the changes, and then we can read what it would read entirely.
Madam Chair, may I ask a question? If there was a question I had that was before D, I had a question about C. Do I do it now or wait until since C came before D?
Go ahead, member. Yeah. Go ahead, member.
Minister, good morning, everyone. Good morning, Minister. I remember having this discussion with the SG's office, and my understanding is that over time there has been a change, and the CEO is actually a member of the board, an official member of the board. In fact, the discussion indicated that boards no longer had ex officios, but in our case, we need to have them. That's the new boards. We need to have 2 at least. But please let me discuss it with her again. But this discussion went on.
And from the SG's office, Minister, because I've seen new boards and they have ex officio members. I would love that to be confirmed, as you have suggested, because the CEO should be an ex officio member.
So Mr. Poorman is online.
Hi. Oh, sorry. Good morning, Chairman. Good morning, everyone. I didn't hear the question that the member raised. I heard
Go
the
ahead,
response from Dr. Gordon.
My question
And
was, why is the CEO a full member of the board versus being an ex officio member of the board?
okay, thank you. I don't recall the discussion that took place in relation to this one. Perhaps it was one that was dealt with by the SGR not, but she's not able to attend the meeting today, and I don't want to purport to represent what may or may not have been said by way of explanation of the current trends in legislative practice. So I wish to defer. I'll try to contact just to get some insight, but I'm not in a position at the moment to add to the discussion.
There is a circular from the Ministry of Finance. We should look at it. I hope I'm not, I'm recalling properly. But we should look at that circular.
That's what I wanted to ask, Chair, because there seems to be some sort of a new practice where CEOs now become ex officio members of board, meaning that they don't have any voting rights. Now, Mr. Foreman, this question has just come up. It's the first time we are discussing it. And yes, we'd want to understand what would have been, in the first instance, if there's a practice in law to constitute such changes, and then the question of a policy direction, if one has been instructed by the Ministry of Finance in this regard. So it would be good to see that policy, if a policy has been instructed. And certainly this would guide us. We also would want to understand and appreciate if in the setting up of boards in relation to any other legislation, what would be the practice? So certainly this would guide us before we make a determination. But member Natalie Campbell-Rodriguez has raised a very important point, and we want to be ensured that we are in accordance with the practice.
But I think in addition, Senator Gill, if there is a change in practice, as is suggested by the technical team, it would be good if all parliamentarians were informed of this so that we know that there's a change in practice.
And Minister, may I suggest also that we look at, is it 1B as to whether or not the child care and family service person, whether it shouldn't be a representative, because if we have some issues with the CEO being present or being available at a particular time, it might mean that that position goes vacant. And so maybe we want to change the language to say a representative appointed by the minister from that agency. Thank you.
Minister, good morning. Or Chair, good morning.
Please go ahead, Ms. Wilkins.
I think the issue is that the CEO answers to the board, or in this case, the council. So the CEO is there in a functional capacity, and they have to explain how they have implemented the board, the council's directives and the council's policies. So I forgot about the camera. My apologies. Yes. So the issue with a CEO being a full member of a board has to do with the person who must implement and answer to is also somebody involved in decision making. It's problematic, and I think that is an issue. But absolutely, the CEO must be present at meetings and answer to the board. to the council.
I'm still not clear. So does that mean
I
the
think
person
she's
is ex
saying-
officio?
No.
So they don't sit on the board, but
No.
instead answer to the board and be present,
be-
as is the norm?
That is the reason why there would be ex officio, yes.
So it should be, we should
Rather
correct
than a
this.
voting member of the board.
Okay, and in terms of B, that was just raised by Senator Brown, would that person be ex officio as well, or a sitting member of the board? I would say sitting.
The way in which it is written, it would be ex officio, or whoever holds the office of chief executive officer would automatically be the person who would be a member of the board, and it is by virtue of them holding that office, which is really what ex officio means.
Sorry,
So
please
how
can you
would
help
we-
me because I'm a little
How
unclear of
would
what
we
you're saying.
explain then
Yeah.
the chief executive officer of the council? Because
Well,
you said
let me-
they report to the council, which I agree, but should not be a voting member on matters because those are the matters that they have to carry
Themselves
out.
implement.
Yeah, but how do we explain that here? But ex officio only means by virtue of your office. It doesn't speak to voting rights.
To whether you can vote or not. Yeah. Yeah. So I was only saying that the concern that which would need to be properly distilled, examined, and decided on is whether it is desirable for the CEO of the council to be sitting there in two capacities. It can be a conflict because then I don't know. It could be a conflict. Then let me just leave it at that. In the case of the CEO of the Child Protection and Family Services, it doesn't mean that that person won't be able to vote. It just means that whoever sits in that chair, whoever holds that post, is the member of the council,
Madam
which is
Chair.
essentially what ex officio.
A question then, because I'm a little confused. So we're saying B and C are ex officio members, but that does not explain that they should not have voting rights.
Not on the voting rights yet.
Oh,
Yes, you're correct.
Right, we're just-
You're correct. It
right.
doesn't speak to voting rights.
So
As
is it
written here? It would be that they would be full members,
okay?
unless
So-
words that indicate that their participation is purely, or in the case of the CEO of the council, is to answer to the board and to be responsive to the board.
So my suggestion, Madam Chair, I think the person from CPFSA should be a voting member of the board. I don't see that conflict, and it should be the chief executive officer or representative. You know, we rephrase that. I think that person should be allowed to vote. However, and it should be ex officio so that they know they're there in their capacity of their job. And C, however, should not have the right to vote because in my mind, that's a conflict. So C, the CEO of the council should not be able to vote in my mind. So I don't know what my colleagues or yourself think, Madam Chair.
Good governance says that the CEO reports to the board, right? They're present at the meeting. They're there to answer questions, to give comments, to do presentations, and to carry out the mandate of the board or the council.
Chair, I would have no problem with the person having voting rights, except for the regular conflict of interest issue which may arise, so that if the person is in a meeting and a matter comes up in that meeting which raises a conflict of interest, the person probably should recuse. And I know there was a recent case involving a teacher somewhere in St. Mary, where the issue of the principal, who was a member of a committee, was present in the room. And I don't want to go into the details of that, but suffice it to say that the persons on such a board should be schooled in the issues of conflict of interest, and therefore, while not being denied the voting right, must exercise those safeguards when it comes to issues in which they may be involved one way or another. And it's only in that context that I put a restraint. I have no problem with the person voting regularly.
Member Brown, how does it work if the council proposes something, right, to be carried out by the CEO and the CEO votes against it? How does that work?
Well, I take it that the council is going to deal a lot with policy issues, and where it comes up, for example, a disciplinary matter like that in which one might have been a weakness or could potentially be a weakness, then the regular conflict of interest clause and principle would apply. So I would have no objection to the person. Because there may be a lot of policy issues on which a person may wish to vote, and I would certainly want them to be able to do so.
Madam Chair, there is also, I think we might be debating something that is moot. I would suggest that the technical team revisits the public bodies. There is a document that was released from the Ministry of Finance in recent times that now deals with the governance of boards. I could be wrong, but if I remember well, there is something in it that speaks specifically to CEOs. And of such, I would suggest that the technical team looks at that document and see what it says about it. I don't know if you're Mrs. Gordon-Jones. I don't know if you know the document I'm referring to.
Sorry, I believe you're talking, Senator Rodriguez, Campbell Rodriguez, about chief executive officers or chairman, executive chairman. I don't think I can't recall the document addressing the specific issues.
It won't hurt to look, though, right?
No, absolutely not.
Right.
But
So let's just look to be
indicating
sure.
what my recall is.
Chair, we may also, whilst we're speaking of conflict of interest now, we may also want to consider when we get to 12, one, especially B, where Senator Brown may have spoken about, conflict of interest in a particular matter. And B suggests in the case of any other matter, take part in any deliberation or decision of the board with respect to the matter if the board decides that the interest in question might affect prejudicially the members' consideration of the matter. So in that case, that is where the individual may recuse themselves. But when we get to that, we can discuss that aspect of it in conjunction to the concerns that we are raising now. I will be on page 65.
All right. Ms. Gordon-Jones, let's carry on.
Madam Chair, before we carry on, I just want to reserve the right to ask the question of why the number was dropped, but I remember Mrs. Gordon-Jones says later on we'll understand why.
All right, yeah, just walk through. Yeah, so we will answer the question as it relates to the Chief Executive Officer of the Council, even though we're moving on, but we've made note of that, yeah. All right, 1D.
So as indicated before, under 1D, we have reduced 5 of whom shall be licensed to practice as a teacher under this Act to 4. For 1E, we have increased 2 individuals being representatives to 3 individuals being representatives of a university, 2 of whom shall be representatives from the University of West Indies School of Education, and 1 from the University of Technology, and all of those shall be licensed teachers.
Madam Chair, may I ask why the University of the West Indies gets 2? I mean, I'm a graduate of the University of the West Indies, and I love it. It's the premier institution. But there are other universities in Jamaica with an education department. There is NCU.
Member, let's move through before you make the comments. Let's see the totality. Let's see the totality of the changes, because that other universities, if you read down below, I think it is there.
No, but F is, Madam Chair, for an institution that's not a university. E is the one that handles universities. And if we're increasing to 3 and giving 2 to the University of the West Indies, but NCU, for example, has an education department.
And if I may, Madam Chair, that was the discussion we had earlier, and an independent person was recommended to be on the committee as well. So I'm in full agreement with what my colleague stated earlier.
Sorry, member, I didn't hear what you said.
In terms of the 2 slots, you stated, Madam Chairman, that it's best for us to look through it first, and then we'll obtain our.
All right. All right, could we go through the totality of this?
In terms of 1F,
Member, right.
in relation to 1F, we have increased the number from 2 representatives to 3 representatives. This is in relation to the Teachers College, so this would also capture VTDI. In relation to 1G, we have increased 3 nominees to 4 nominees, and this is to include a member from a trust. And from that, at least 2 nominees shall be licensed teachers. So it's changed from at least 1 nominee shall be a licensed teacher to 2. That's the proposal. In terms of 1...
Sorry, am I correct that the religious community who came before us was concerned not so much about the insufficiency, but that there should not have been a requirement for a licensed teacher? Not that I support it, but I'm trying to read their thing was to say there shouldn't be a requirement, a qualification for a licensed teacher. Now we're saying 2 licensed teachers. So I'm just raising that from the point of view of what I understood them to have said.
So, Member Brown, they would have the 2 nominees that they requested. I mean, they said as significant owners, the trust should have 2 members on the board. And here it is, they're able to have, they're given 4, 2 of whom should be licensed teachers. And so there at least 2 on the board is satisfied.
We're giving them 4, is what you're saying, Minister.
Right.
Am I correct?
If we raise it to 4, then they'll have a chance to have 2 nominees that are non-teachers and 2 that
And 2
are
teachers.
at least licensed teachers.
All right.
Yep.
Cool. 50-50.
In terms of 1J, The proposal is to 1J and 1K. The proposal is to remove the voting rights from the attorney at law and the person who has experience in finance or public administration.
The rationale, thank you. We'll tally up the numbers at the end, and then you can see. But I
You're
just...
taking away the voting rights from now?
The lawyer and the finance person.
And the finance person.
So only teachers talk to themselves?
So we're leaving the teachers now with all authority.
I don't agree with taking
We are
away
leaving the
voting
teachers to
rights.
manage themselves.
No, we don't.
No,
we don't
no.
agree with
But you
taking
see,
away the voting rights.
I don't want it to appear that you're taking away the independence from those who are part of the body, who also can make decisions. And you're leaving the authority now to make decisions with a group that has a clear community of interest, being all teachers.
You can't have, you don't get the best decisions when a group is homogeneous. You need a little bit of diversity, because if everybody is the same, talking to each other, you're going to get the sameness. So you need that external assistance. I'm completely against this.
That's like the teacher asking the class a question and answering it.
None of the
members are
professional
not...
boards, the doctors, the lawyers, the boards are managed by them. And it has been the argument of the Jamaica Teachers Association that if we're going to set up a council, then the council must comprise predominantly teachers.
I don't have a problem with that.
The percentage should be no less than 60%.
No, but I don't have a problem with that. Where I have a problem is that, as Senator Campbell Rodriguez spoke about the homogeneous grouping, similar mindset, similar thought process. Now, you may have a situation that a decision ought to be made, and you're thinking all. Like, it's just like you have some bankers in the room, and the bankers go and think alike. You need to have that element of independence being engraved in the grouping to provide that independent thinking. And I don't agree with taking away the voting rights from those who are not part of the homogeneous grouping that would be part of a community of interest.
Should we do that, we'll have to increase the number of members of the board in order to meet the proportion of teachers.
You don't need to increase the number of members. What you need to do is to give equal rights in terms of voting.
They're already members. That's one of the next one. They're already on the board. But I understand what you're saying in terms of the numbers on the board and the voting. But I think what trumps that is that the best decisions are made when the grouping is not homogeneous. So that overrides, in my mind, best decisions for our vulnerable, which are children in this society, takes precedence over that thought process, in my mind. We can't just have educators talking to themselves. It is not the best. So if we have these additional 2 persons who are already on the board, one is an attorney and one is a finance person, I think having those 2 persons, it will help the process. Because everybody else is an educator.
Senator Brown, before you, because I'm putting this directly for your interests. I have a hearing for a bank employee who would have had a transgression in relation to the rules of the bank. And I'm appearing before a panel of leadership in the bank that is going to hear the matter. And I've raised concern that there's a community of interest. All bankers hearing the matter. And it is likely that all bankers in a room may stick or form a common decision. There's no independence in that. And this is the same situation that would be arising here. What are your thoughts on that?
You're a very good trade unionists. And that certainly, especially since the worker committed a transgression, that certainly would be a nice tactical position. My own view is in respect to the issue of voting rights, which is what we're debating here. Why should I sit on a board? Why should I give up going to court and earn money? Why should I do all of these, give up these noble things to come on a board with which I have no vote? So I am of the view that if they're sitting on the board, they should be allowed to vote on matters. Otherwise, we're likely not to attract the best, if anybody at all. So I am for voting. Come on, you and I can talk about how we deal with that issue, because when you go before judges, all of them have the same thinking. But we deal with that another time, my brother. So I am for voting rights for these people. I don't know that it changes the composition of the committee, because as Senator Campbell Rodriguez said, they're already members of the board.
Okay, so I believe we have a consensus from the members that the attorney at law and the finance person should have voting rights. All right, wonderful.
Madam Chair?
Yes?
It's me in the house. Before we move on to 2, I know we said we'd go back to E, but I just wanted to say, if we're not going back to it now, I just want to get some information from the technical team. In my mind, there are 4 universities in Jamaica. Or do I wait until after because we're at the end of 1 now, so.
We're not at the end of 1, through you, Chair. In terms of 1L, I'm not sure if I'd indicate that it has been changed from 1 to 3 teachers for outstanding performance in education.
Could I ask what would be the total now? Just save me the maths. What's the total number of membership on the board with that proposal?
I tried to maths it out.
The total would now be 29.
Originally was 23. It was 23 before, which is a big board. Yeah, a lot of people.
Is there a rationale? I'd love to hear the rationale before voting no.
The teaching council. Minister Green has his hand up, or had it up all along. Go ahead, Minister Green.
Firstly, Chair, apologies. My camera seems to be giving me some challenges this morning. I'm trying to rectify, but I didn't want to log out when we were having this discussion. Member Brown asked a question. I wondered what was the overall composition now, and also what is the percentage of teachers on the board now. After that, I'll probably make a point.
Are you talking about the proposed or what is originally in the book?
Proposed. What is proposed?
Go ahead, Ms. Gordon-Jones.
So based on this proposed change, the total composition would be 29. And of that 29, 15 of the individuals are registered and licensed teachers.
And the licensed
teachers.
Licensed teachers.
So they are licensed teachers. So that means they are also registered.
Okay, registered and licensed.
That's almost a 50% split in terms of teachers. What was the split prior to?
So the composition before was 23. I would have to work out how many of the 23 were licensed teachers. The previous composition is 23.
So okay.
And just to note too that the CEO of the council and the head of the division for school services in the ministry, those persons are registered teachers, but not necessarily licensed teachers.
So, Chair, just to say, I believe that the majority of the board, a clear majority of the board, should be teachers. Right? I don't see, again, for all professional institutions of this nature, it is normally constituted of a majority of your peers, right? And I don't expect anything less for the teachers. I believe our teachers are quite capable of administering justice and standards across the sector. So I think we have to ensure that even if we're raising the numbers, and I take it that the numbers have been raised based on advocacy. But for me, the most important thing is that we definitely should have at least that 60% number that are teachers. So I just want to ensure that in any alignment or any composition of the board, that a clear majority, which I would say 60%, are teachers.
And just if I may, Chair, that is why we had in terms of voting, we proposed the taking away of the voting rights from the attorney and the accountant to have that majority.
So I think, like Member Brown, I have a little challenge with, and I know there are limited instances, and I think Member Rodriguez spoke about oftentimes when CEOs report to boards, they don't have a voting functionality. Sometimes when permanent secretaries are on boards, they don't have a voting functionality. But I would have a challenge if a significant number of the board members who are part of the deliberations do not then have a vote, right?
Member Green, there's only
yes.
one member in contention, and that's the Chief Executive Officer of the Council. But
no,
everybody
but
else
what
has
was
a
just
vote.
said is that the attorney, etc., would not have a vote.
We said no
we're
to
past
that.
We've said they must have a vote. The attorney at law and the person with experience in finance or public administration must have a vote. So everybody, the only position that we have been debating is that of the Chief Executive Officer of the Council.
Okay, so just to go back to my original point then, Minister, I believe we have to ensure in the composition that 60% is made up of teachers.
Agreed. Madam Chair, can I ask a question if Minister Green is finished? I get the impression we're making a distinction between registered teachers and licensed teachers. And it is using that we're sort of being tongue-in-cheek about the numbers. Because...
No, because everyone has to be registered.
Right,
first.
but if they are, because I noticed that it was said, unless I heard, and I stand to be corrected, that the person at A and C are registered teachers who do not need to be licensed. That's what I'm understanding from the comments that were made just a few minutes ago, which means there are 2 educators there on the board. They said that they
don't. So we will have teachers who are registered and licensed, and then there will be other persons. What?
But earlier, a few minutes ago, the person in capacity 1A. Am I Correct, Mrs. Gordon-Jones? You said person in 1A is a registered teacher. Is a requirement of the job. So the person is a registered teacher, not necessarily licensed, but registered. And I'm saying if we have those cases where we have registered persons who are not licensed, they're still educators. So we're using the word teachers and referring to it as licensed teachers. But what we're really concerned about are educators on the board, the number of educators on the board. And I'm speaking as to what my concern is. So to say the person doesn't count towards the 60% is a little bit, is a wee bit gray area.
Yeah, but remember the 15 who are proposed are registered and licensed.
Someone registered.
So then we would be over the 60%.
No.
Madam Chair, do you mind if they go through and tell us who these persons are? Because I don't know who these extra persons, I'm not seeing the extra person.
Remember, you will probably know that the structure of the board has evolved over time, coming through a whole series of consultations, including national consultations. And we have gone from ex officio to no ex officio, and all of that has happened. The two persons, the lawyer and the accountant, were put on the board because of a discussion among ourselves and a realization of what happens on the commission that now exists, that these are competencies that the board will need. Now, what we probably could do is to have these persons as advisors for the board or to the board, because at the end of the day, the council is about teachers.
Members, let's move forward. Dr. Gordon, no. They're board members, full-fledged board members.
Because we might be, so, yes,
Tally.
please.
All right, so draw up 2 columns, call it registered teachers, and then the other column is licensed teacher, all right? No, registered and licensed. Registered separate from licensed, all right? And then you can put not a teacher, all right? Or other, all right, other. So the first one, the head of the division responsible for school services, registered teacher, all right? 1B, Chief Executive Officer of Child Protection and Family Service or representative, other. Yeah. That's 1B. 1C, Chief Executive Officer of the Council. All right, but other, they'll be in the column of other, right? Okay. All right. 1D, 6 registered teachers nominated by an association recognized by the ministers representing the majority of teachers in Jamaica, 4 of whom shall be licensed to practice as a teacher. So it's assuming that they are registered too, right? 6 registered teachers.
So we should put four on the license and 2 on the registered. So that would be 6.
All right. 1E, 3 individuals being representatives of a university that's registered in Jamaica. At least 1 member shall be a representative of the UWI, nominated by the Vice Chancellor. Okay, but we have to come back to that one. All right, let's use what's here and then we can say. 3 individuals. So that's 1E.
Is that 1E?
Mm-hmm.
Right, and so based on the proposal, it was indicated that those individuals are supposed to be registered teachers. Based on the change that I have on the paper, it says those 3 persons should be licensed teachers. That's the proposal.
For the SOEs.
Right. Okay, 1F, 3 representatives of teacher education. 3, there wasn't a change to 3? The change to 3 of a teacher education and registered and licensed. So where do we put that?
It says 2 of which shall be licensed teachers. So we'll have 2 under license and 1 on the other.
Okay, and 1 on the other. Okay.
That is for
1F. Right? 1F?
right. 1F.
1F.
1F. 2
All
shall
right.
be licensed, 1 other.
All right, 1G. 4 nominees of a person who or body that minister recognizes as representative of religious denominations which own educational institution, of whom at least 2 shall be licensed teacher, right? So 2 other and 2 licensed. 1H, 2 nominees of bodies appearing to represent parents. I'd like that to move to 3. No, I'd like it to move to 3, but we can use the 2 for now. 1H. Yeah. 1I, 2 nominees of bodies appearing to the minister to be representative of the interests of independent schools, one of whom shall be registered and licensed. Yeah. Attorney at law, other.
Chair, I'm sorry, Chair, just looking back at that, should there be, to ensure that there's no doubling up, should there be a distinction in I that the independent schools wouldn't be any of the ones owned by educational institutions? Because it could be.
I think
But an educational institution would own an independent school, I just wonder.
But independent, that's what independent means, so, that you're not, it's not government. Yeah, it's private, owned by, it really means non-government.
But you could have a private, an independent school owned by a religious institution. You could.
So what's the real distinction you want to make, Ms. Wilkins?
That in I, you're talking about an independent school not owned by an educational institution. So there is no doubling between the G and the I, so you actually do have.
Do you mean religious? Do you mean religious? Because you said not owned by an educational institution.
I'm sorry, I meant religious, yes, religious.
Yes. Very good distinction.
Okay. 1J, oh, we have that already, other. 1K, other. 1L, 3 teachers are registered and licensed, right? 3, we're counting the proposed.
Asking for 3 on the grounds that you want to make the 60%. So we need to use the old so we see if there's a need for it. Because if there's no need for it in terms of numbers, why would we do it? Do you have another rationale?
So the change for 1L was not the only change to make the 50%. The overall change was aimed at trying to get a 60% membership.
Madam, if R and L are both educators, we would find ourselves with 16 educators and 10 other.
9 other.
No, it's 10 other. It's
Well,
10
if you
other.
include the CEO, that's 10.
No, I didn't include the CEO because they don't have a voting, so I didn't include them.
All right. That's
So it's 10 other.
9.
And then license, I had 13, and registered, I had 3.
There are 15. I counted.
Sorry?
So I have 6 registered, 16 licensed, and 9 other.
No.
All right, let's go through it again. It's important that we understand the composition. So head of the division is marked as registered, right? Head of, guys, hello, members. We're on the clock here, we're on the clock. So 1A is a registered teacher. 1B, just so the numbers will tally. I mean, we're not talking about voting rights right now. So 1B is other. 1C is other as well. We're just tallying up. All right. 1D, 6 registered teachers. All right. But 5. Four of whom shall be licensed to practice. So 4 on the license, 2 on the registered. 1E, 3 individuals being representative of a university. At least one. All those 3 are licensed. This is 1E, right? All those 3 are licensed. 1F, 3 representative of teacher education. And they shall be registered and licensed.
Two shall be licensed.
2
shall be licensed. It didn't specify the other. Right.
All right. 1G, 4 nominees of religious denomination. 2 shall be licensed teacher and 2 other. 1H, parents, so that's under other. 2, 1I, 2 nominees of bodies appointed to be representative of the interests of independent schools not owned by religious entities, of whom 1 shall be registered and licensed. So put 1 under licensed.
You would
and
put
1
that under licensed.
and 1 under other. 1J, attorney at law, other. 1K, finance or public administration, other. And then L, 3 is what we said. 3 teachers who are 3 on the license. So if you count that up now, 7, 8, 9, 10, 11, 12, 13, 14, 15 licensed, 3 registered, 9 other. How does that make it? Sorry, 10 other, including the CEO. That's 28. That's 28.
Dr. Gordon is just indicating to me that the university is supposed to be 4 and not 3.
Okay.
3 license
Would be other.
and 1 other.
So that's 1E.
3
So we
all
take-
licensed.
Huh?
Member was asking what we had before. So we're saying we had 3 and all 3 are to be licensed teachers, but it's supposed to be 4. So from the 4, 3 should be licensed teachers.
And 1?
And 1 other.
And 1 to other,
And
right?
that takes care of the independent university because they don't.
11.
What was the rationale for the representative of the university being licensed teachers? I'm not sure I heard. It's not in it now, and you're adding that. What's the rationale?
They train teachers.
We do the adding up first and then we
has
come
a
back.
teacher.
But why do they have to be licensed? They're not part of the remit of the council.
What? I'm sorry. What was
Because
that? We didn't hear you, Nadine.
They're practicing teachers.
They're in tertiary institutions, and your remit is not tertiary institutions. Why are you requiring that they be licensed in order to be? They're
Is it that
there
you want to
because
ensure
they're
that they are
University didn't
practicing?
say.
They're teacher educators. So their practice has to be up to date. which
But
is
this
why
did
they're
not say
licensed.
they should be teacher educators. This said representing the university.
Yes,
University, School of Education.
that's the point.
No. But
it
there are
doesn't
other
say
people in the
that.
School of Education, so you have to change the wording to be more specific because
We'll put
I
that
did not
in.
interpret it as such either, that it was the educators.
Yes. Yeah, the educators.
No, you say it, but-
School of Education.
School
Their
of Education.
School.
Two individuals being representatives of a university that is registered in Jamaica. And at least one member shall be representative of the University of the West Indies nominated by the Vice Chancellor of that university. So it
Right,
makes
so
no distinction.
Right, so our
No, it
proposed
doesn't.
change would have clarified that they should be licensed teachers.
Right, so you want
Yes.
those practicing
Right,
to be the ones nominated for this particular role.
correct.
And you would have expanded it now to an additional one.
1,
And is there a distinction as to where this additional one is coming from?
no.
But there's a little bit more in what was said as well, that it would be a university that trains teachers.
But Ms.
Which
Wilkins,
is a
can we do the
further- which is
numbers
different.
first? Can we finish with the numbers? Because when we get numbers, we can come back to whether or not we have
Okay.
met the 60%.
The School of Education
Members,
trains
what we have,
teachers.
what we have currently are 15 licensed teachers, 3 registered, and some of them are both, but we just put them in the license column. If you're licensed, you're registered, but you can be registered and not licensed. And 11 other, if you take out the CEO, that will be 10. So we have a total of 29. And if we put the license and the registered teachers together, we get 18 out of 29.
Madam Chair, can you remind me, did we include 3 for L in our tally?
L, I, J, K, L.
When we were tallying?
3, yeah.
Because, Madam Chair, for me, I don't see why we need 3 there, and we're within the 60%, aren't we? Use your words. Sorry? I'm not hearing you.
Right, we are.
Right, that's what my math said. We're over the 60%. So, Madam Chair, I want to move that do not move to 3.
If you remove the 3,
I would propose that we
if you
add
revert it-
that to the parent representative.
the 60% would
I would
belongs-
agree with you, but
Right.
no, you heard what Minister proposed? Don't make it 3 there. Make it 1 there, and then we move the additional number that you may want to parenting.
All right, so if we move those, if we currently have 15 licensed teachers, which would include those at L, Those 3 at L. No.
Yes, we have 15 licensed and 3 registered.
So is it that we don't want most to be practicing?
Isn't it just
Educators.
educators are being
Educators.
licensed?
Only looking at 1L, where originally it said a teacher who's registered and licensed and recognized for outstanding performance in education. But now the proposal was to move that to 3, from 1 to 3, and we're saying take that down to 2.
1 teacher and 2 other. Coming from parents?
Right, so I wanted to increase the number of parents that are here. What
Madam
we
Chair,
have is
I am supporting your if what you're saying is, Madam Chair, for L, we
Yeah.
keep it as originally written here, where it's 1 teacher, licensed and registered teacher who is recognized for outstanding performance, and we add onto the parents, which is H,
right. So
because I
we
do
move that.
think parents are a major stakeholder in education.
All right, so we leave 1L at 1, right? So that would take the number down to 13. And move parents, H, parents to 4. So that would take us to 13. So we still have 16 teachers, whether registered educators. Let's see what that says now. All right, so that takes us to 16 total. And do we have to make a decision about this, the CEO's position, voting or no voting? Because that will make a difference in the numbers.
We have to maintain a teaching council. It is a council of teachers for teachers to manage themselves.
I'm responding to her question about the CEO, whether or not the CEO votes. That's what I'm answering from Mrs. Gordon-Jones.
We have to discuss it with, we have to look at the Ministry of Finance, Finance's circular. And we have to do that because we started out, the first structure of the board was all, we had about 4 or 5 of these persons who were not voting. And then we got information that made us change. So we'll have to go back and find out the source of the information that caused us to change.
Minister, Chair, in
Yes?
terms of the 2 that was taken from L, where are we putting those 2?
Parent. H, parent,
So you're now raising parents from 2 to 4.
yes.
Thank you.
So we have 13 licensed teacher, we have educators, we have 16 educators and 13 other, including the CEO. Okay, so
Madam Chair, normally,
they would
and,
still be in the majority. They would still be the majority.
and normally we don't count a non-voting member if we're making up a tally.
All right, so if we use 28, so that's 16.
Has to be an odd number, no?
So that'll be 57% if we use the 28.
Madam Chair, is we need an odd number
No, what?
for voting. Because of voting, you need to have an odd number of voters to not
No,
have
but
deadlock.
How could you have deadlock?
If they cast a vote and it's an even number, there's a possibility you have 14-14. Unless you give the chairman a casting vote, which, right, yeah, you'd have to put that in if you have an even number of voters.
Okay, but I'm just saying 28 is because we didn't include the CEO.
Right, but she's saying it's fine because we have the chairman as a casting vote.
Okay.
If we have deadlock.
All right.
Correct, Mrs. Gordon-Jones?
Yes, it's at paragraph 10.4.
Off.
Page 64. 10.4 on the first schedule. Paragraph 10.4.
All right, so you said it's the chairman of the board, the deputy chairman of the board, or other member. Who would be the other member?
That's in the case where the chairman or the deputy is unable to preside. Then the members would normally elect the person to chair.
Okay, all right.
Chairman, can I ask about L, a teacher who is registered and licensed and recognized for outstanding performance in education? So this is meritorious in nature. Right. Right. So is it a lifelong appointment or is it tenured
With the board.
with the board?
It would be with the board.
It would be the life of the board, no?
The life of the board?
Yes.
Okay.
Yeah.
But, Madam Chair, the fact that someone thinks to ask a question.
No, but when you take the submission to cabinet, it says on the cabinet submission, the life of the board, it says these members are there for whatever period is described, no?
To ensure that it goes in conjunction with 6.2. Yeah, tenure of office.
Does any board have lifelong members?
You see, in this case, the concern that I have in this case is that the appointment of this individual is based on merit. So I want to make sure that no one assumes that because I've been treated based on merit for outstanding performance, you don't take away the appointment based on the outstanding performance.
No, but when you, remember, Gail,
Yes.
when the members get their letter of appointment, it specifies the period of time.
I understand that you're not
Yeah.
chair. I understand that you're not chair. But this is what I would consider to be a unique type of appointment in that it's being done based on meritocracy. Nothing is wrong with it, nothing is wrong with appointing at practicing. And again, you asked for practicing. So the person is practicing, is based on outstanding performance. What if the person starts to falter in performance?
But it's not, it doesn't say practicing here either.
It says licensed.
Yeah, but you cannot be practicing unlicensed. So that's something else that should be, very distinct.
Well, I look at the licensed teacher as license means a license to practice.
Right.
So it doesn't say it's practicing.
It doesn't say you're practicing, so you can hold a license. in my mind, the person doesn't have to be practicing. But the original point made by Senator Gale, where we need to just state, just in case, because even though someone's letter, Madam Chair, might state for the life of the board, 3 years, 2 years, whatever, someone could challenge in a court based on the wording here. So what we've just to protect ourselves and to prevent any ambiguity, we could just state clearly that the person's tenure is for the life of the board. Because sometimes when we're appointing based on merit, you know, the feeling may influence the how one interprets. Does it hurt, Mrs. Gordon-Jones, to just add in something, do you think?
So wouldn't you have to say that for all the others?
I think,
then?
No, because this one is merit, Madam Chair.
But it says at 6.3 that every member shall be eligible for reappointment. No member shall be permitted to serve longer than 2 consecutive terms, and the term is, it shall not exceed 3 years.
All right. So members, I want to hear from you in terms of a vote on the proposed composition of the board of the Jamaica Teaching Council. There's only one item outstanding, and that would be the voting privileges for the Chief Education Officer. I'm sorry, the Chief Executive Officer.
One E also proposes, Madam Chair, that 2 of the 3 members be from the University of the West Indies School of Education.
I thought
of the 4?
we're going to reserve, we're going to say 1 from UWI, 1 from UTech, and 1 from another. It's 4?
Okay, but will we say...
Other institutions.
Madam Chair, as I said, as an alumni member of the University of the West Indies, I'd love all 4 to go to us. But to be fair, we have 4 universities that deal with education in Jamaica. We have UTech, MICO, NCU, and UWI, that I am aware of.
MICO would be included on the teachers' colleges.
But it's a university. So that's different from a university. Okay, so we have 3. So I don't know, why would we not give 1 to each verse? I understand that it's 4, but I'm saying we have specifically said 2 to the University of the West Indies. Why is the University of the West Indies getting 2 versus getting 1 and spread out the others, allow them to self-select or whatever the process is, but why are we giving 2 to the University of the West Indies?
Member Rodriguez, we will go with 1. Members?
I'd propose a formulation which says at least 1, which allow for some flexibility. And bear in mind that even if we have 4 now, we may have 10, 5 years' time, and it's not a legislation for 2023 only. So give ourselves flexibility in the formulation we use. So if we say at least 1, it allows in certain circumstances for more than 1, and it allows for the split. So that will be the language I'd propose.
I would support Member Brown on that formulation. At least 1 from the University of the West Indies.
Members? Agreed? Okay.
I'm in full agreement to 1 to the University of the West Indies as well.
All right.
1 or at least 1, Big Rob.
1.
All right, members, we will move on, noting the points that we have to come back to with regards to the Chief Executive Officer of the Council and the voting right
Minister,
there. Yes.
Chair, before you go, Just want to be clear so that whenever we are giving the drafting instructions to the Office of the Parliamentary Council, in terms of 1E, are we naming the University of Technology as well? The University of the West Indies is named, at least one from the University of the West Indies based on the agreement of the committee. But are we going to go with the proposal to name at least one from the University of Technology?
Do we have to name the institutions, or do we know who they are?
So we are currently going to name the UWI,
From your name one,
School of
You have to name
Education.
the other.
you have to name the other because it also notifies those universities to which a nomination should come from.
So we have to name the 4.
We're naming the 4 universities.
I really don't oppose to naming the 4. I think we have to give ourselves flexibility.
Government funding projects that would seek to engage on attached youths are something that we.
Go ahead, Member Brown.
Yes, Minister. I am of the view that we should give ourselves flexibility in the drafting, but because of the age of the first 2 being named and the breadth of their work over the many decades, I would have no problem naming the 2. Maybe, Minister, you may not want to vote on this one because of where you sit, Papi, and that zone being so special to you. But I would believe that those 2 should be named.
We agree, Minister, that those 2 should be named, UWI and UTech. In fact, UWI plays a major role in the teaching program, not just training teachers, but setting up the programs. They're important players, and so they should be named.
All right, so what? Sorry. Go.
So we'll say 1 from each, 1 from UWI and 1 from
And
UTech,
one from
and
UTech,
then
at least.
at least, okay.
And then the minister now can decide the appointment of the others, where they come from. All right.
Minister, Chair, it
Go
just
ahead.
occurred to me, has any effort been made to determine whether these institutions are willing to serve on the council?
Yes, well, they came and made submissions, and they all, if you look at, they were
very
very
vocal.
vigorous in their submission. In fact, UTech, 1 member for UTech to be licensed teacher. If you look at the School of Education at UWI, they wanted 3 persons. Teachers Colleges of Jamaica.
Okay.
Yeah, no, they
Yes,
were all
and-
very
yes,
interested in being
agreed.
represented on the council.
Yes,
Well, if I was a university and I'm not included in this, I would feel left out.
That's why it should specify that it's a university that trains teachers. If it is qualified like that, then you won't have that.
Somebody
Because
has
not
their
all
phone
universities train teachers.
I'm sorry, Ms. Wilkins, didn't quite understand what you're saying.
Oh, no, I was saying that the danger of just saying university would be minimized. That issue wouldn't be so bad if you ensure that it is clear that it's a university that trains teachers.
Right, I think that's what
Yeah.
they revised.
Right, so that
no?
wouldn't just
say?
be any university.
Right,
we-
okay. It should be
Chair.
specific to universities with,
So we could take a similar language from 1F. It says the institution that provides teacher education should be the university that provides teacher education.
okay. All right. Thank you. We'll move on to 2. And I have disqualification for appointment. Does, in 2C, does moral turpitude include a lot of things? No?
Chair,
For
it is a
technical
word
persons,
from the
how
past
wide?
that we continue to use, but it generally connotes conduct which is dishonorable.
How is dishonorable decided? How?
I think it turns on the specific circumstances. I don't think we have a
Miss Wilkins,
perfect.
Miss Wilkins,
Yes,
you have persons now asking for expungement of records in relation to this cause, you know. Would that be also taken into consideration?
Expungement of records that I'm aware of would be criminal records.
It's just criminal records.
Just criminal records.
But you're having some organizations that, depending on those conduct, you have agreements that over a period of time, they are removed. You see, this is wide. This is not just specific to criminal records, but offenses that may take place in general nature. If you're an employee to an organization and you may have been considered dishonest, whether you are terminated or you still remain an employee, that forms part of your record. In this case, to be sure that the person has not been involved to this extent, how are we going to determine that?
Well, remember, they have to be convicted.
And so that's what I'm trying to be clear on. Is this only on the point of being convicted?
Yes.
Okay.
That is what it is intended to convey. They have to be convicted. And about your point about expungement, it's a number of years after that the eligibility for expungement applies.
Yes, that much I know.
Okay.
In respect, sir, in respect to clause 2, Chair, as I understand it, at 2A, if you are a candidate, but you are not successful for the House of Representatives, you can be on the board. If you were a former member of the House of Representatives, you can be on the board. But this excludes only sitting members of the House and the Senate. Am I correct? That's the understanding here?
So my understanding is that it suggests that you are a member. So it would have to be present. Presently a member.
So if I contested an election and lost, the same mindset could take me on the board and the council. But just that if I win, I am excluded.
Yes.
It's not something that I favor.
It
comes up in many legislation. I don't favor it, but I'm not going to oppose it here because it seems to be policy. But it's a bad policy if you ask me.
It's a bad policy. I don't support it either. Serve is to serve. Can I understand, Member Brown, the distinction that is being made? Why members of the Senate or House of Representatives can't serve anywhere else?
I think you'd have to take that up with the Minister of Finance and the Public Service because we litigated that already, and I think we're past that. Members,
No, it's
let
just a
us
question
move-
of just continuing to raise the concern,
Members,
Chairman.
let us move to a comment, a recommendation from Teachers Colleges of Jamaica to say that we should add on the first schedule, it is recommended to add new sections to the constitution of the board. A section called 1M to whatever. There's 1M to 1S to read. These members, these are the additional persons that are requested to be on the council: a medical profession specializing in psychiatry and/or developmental psychology, professional trained in assessing special needs students, an advocate or member of parent support group for mentally and physically challenged learners, a renowned scientist representing the STEM sector, the poet laureate, a renowned artist, and a teacher from Edna Manley College as representative. I'm looking at the matrix, page 33. Yeah. 5 adult students as representative of community colleges, teacher training institution, higher education, 1 representation from parents who homeschool, and the rationale is that the majority of the board will be teachers. The members must possess the knowledge and experience to guide the council in preparing the teaching profession to enable Jamaican students to meet current and future global labor market demands and to achieving our national developmental goals. So,
Did that number add up to 65 minutes or 60?
It would add to a whole lot more. So are there any from among this list that we would consider?
Madam Chair, I think the homeschool, they represented quite well and gave some good arguments, and I think we should consider someone from homeschool. Is that independent? But
It's what? What was your response, Ms. Gordon?
that is independent school?
Yeah, there.
That homeschool would form a
Fall
part
under
of independent school.
But what if somebody from the homeschool, as far as independent, is not chosen? Then they would not have a voice.
Could we reword
I think
to include 1
I'm sorry, Member Rodriguez, you have to find a working mic because we need to get what you're saying on record. Yeah. We have to get
If we could reword 1I, it would help to solve that issue without adding a number, because we could say 2 nominees of bodies appearing to the minister to representative of the interests of independent schools, one of which should be from the homeschooling fraternity. Could we do, is that a possibility?
Madam Chair, if I may, the committee increased the number of persons, parents, representatives from the group of parents to 4. So perhaps it could also be considered to incorporate the recommendation, one representative from parents who homeschool, and also there's another one.
I would also support that as well.
I'm sorry, you're saying for the 4 parents, 1 should be homeschooled. All right.
Right, 1H. But there was another recommendation that could also be incorporated in that. I'm just looking for it.
I am looking at...
The psychiatrist?
No. I am looking at the professional trained in assessing special needs students and the advocate for a member of parent support group for mentally and physically challenged learners. Now, I believe there has been advocacy for the inclusion of persons who are challenged in this way. And I believe consideration should be given. And know when this comes to a particular place to which I reside on a Friday morning, there's a particular senator that Senator Brown knows very well that if he sees this, he's going to certainly support towards this advocacy. I don't believe we should go without at least considering this group of special needs.
Well, I'm also in agreement, and we are progressive, and I think they should be included in this.
So, Madam Chair, H could be modified to incorporate the special needs and also the representative from parents who homeschool. So you could specify an H. One should be that and the other. That one.
Specify homeschool and special needs. So how about the medical profession specializing in psychiatry and or development psychology?
While I originally thought the psychiatrist, psychologist should be on the council, my colleague senator is making a valid point. If there is an issue that arises with that need, someone could be brought in an advisory role to handle the matter. So I withdraw that suggestion.
All right. What was it? What? All right, members, we'll move on to disqualification for appointment. We're still on the matrix, page 33. Recommendation from the JTA in the first schedule, part 2. In addition to the persons disqualified in the bill in order to effectively limit the possibility. Oh, we've done that already. That's taken care of. There is no member of the Senate or House of Representatives, a former yeah.
I don't think we can disqualify former members because you're then saying that once you're a politician, you should never do anything else in society, and you can't contribute anything else in society once you become a politician. That's then not encouraging people to become politicians. And that's acting as though we're tainted. And I take personal affront to it. And so I would definitely not support where you say former senators or members of the lower house should not be. Absolutely not.
Or
sorry, who said that? Who said former shouldn't
JTA's recommendation on the matrix.
I see.
All right, so we will not take that on board. Obviously, we already would have dealt with the okay, we will not take that on board. We move on to page 34. Clause 10.
Chair, before you go to clause 10, in terms of clause 4, chairman and deputy chairman of the board, at a previous sitting, a discussion was for the members to not appoint, but to elect, and the minister appoints. That's 4.2.
All right.
I'm with you on that. I'm with you on that. I had that to raise as well. It came up in our deliberations.
I'd like to go back to clause 3. Sorry, I had a question there. Where it says temporary appointments, the ministry may appoint any person to act temporarily in the place of any appointed person of the board. I don't know if I've heard this before, given that the board has to go through clause 3, temporary appointments. I don't see that because council, maybe you can help me there.
Sir, it ought to be the minister, not the ministry, but there are legislation which allow for example, somebody from one of the sector, let's say the religious sector, is unavailable for a temporary period. The minister can appoint a substitute there. So you're appointing like for like. I've seen legislation like that, and I would have no problem with 3 if it says the minister rather than the ministry.
All right, members, please confirm clause 3. What is it now? 1, 2, 3, clause 3 in schedule, the first schedule, that should be changed from ministry to minister. So moved, so moved. All right, we will move on to clause 10, procedures and meetings. The JTA is saying that the chairman of the board has the authority to call a special meeting of the board if there is a written request of 2 members in light of the fact that the board comprised of at least, that number would be different now, members. It is impractical and it should be uneconomical for the chairman to be satisfied by such a low threshold, i.e. just 2 members, in other words, a meager 8.7% of the board, where the board comprises such a large number, basically.
Minister, the proposal was for the 2 to change to 4 based on the increase in the constitution as well.
We're saying any 4 members can call a special meeting, can request of the chairman to call a special meeting.
Yes, Chair.
And why 7 days, Lord? We have email, we have WhatsApp, we have phones, we have all kinds of ways of communicating. 7 days sounds like a very, very long time. If there's I would imagine a special meeting has to do with something important.
Is it within 7 days? Because that gives the 7 days the outer limit. And it meet your part, Minister, within.
Point taken, member. And we're increasing the amount to 4.
But
right?
Chair, just thinking, even though it's the outer boundary, do you want to limit that outer boundary?
Within 3 days. Three days. If it's a special meeting, 3 days. We have emails, we have WhatsApp, we have phones, we have...
Minister, as you know, under the current education regulations, the special board meetings within 48 hours, and boards are having problem with that, to call a special meeting.
I just had a board call an emergency meeting within that time. And
Some want a lesser time.
yeah,
Yes.
yes, we don't have to send telegrams anymore.
And since we can call some of
Minister,
these meetings virtually.
Sorry, Colin, the means of calling the meeting may allow for some speed, but I don't know what logistics is going to be involved. In other words, 2 members maybe in
But
Montego Bay.
Member Brown, I hope that we include in here the use of the virtual space as well. Give the board the permission to call virtual meetings.
Oh, well, that needs to be inserted. But then again, sometimes all I'm saying is that sometimes even with the virtual, logistics could be a factor. But I'm not one to be pushing that it must be immediate. And so, because there could be many factors. So I don't think we should tie ourselves or constrain ourselves with much earlier. It must be much earlier. I think it could be earlier, but I don't think we should demand that it shall be earlier. That's my concern.
Madam Chair, support your view.
Paragraph 10.1 does give latitude to determine the modality, so they can use any modality that they choose to that they deem appropriate. So there can be virtual meetings.
So members need your vote on this within 3 days. Yeah, within 3 days. Within 3 days.
Minister, I must abstain from that vote. I believe we can set it so rigid that it just doesn't take place. And what if it doesn't take place within 3 days? Because the chairman...
Member Brown, in dealing with school boards, and you would imagine school boards are probably not as, quick to action. But in that regulation, as Council pointed out, it's within 48 hours, and it happens. So with this about changing culture as well, yes.
All right, if you would, I wish to abstain from the rigidity of such a clause.
Duly noted, member. All right, let's move on. Procedures and meetings. Still under the Jamaica Teachers Association, first schedule part 10, for avoidance of doubt, where there is a conflict of interest for a board member, it is recommended that it should be clearly stated that members shall not vote. Members should recuse themselves as well.
Chair, if you look at paragraph 12,
It could be in the matrix.
I think it's adequately covered in paragraph 12.
Okay. Well, yes.
Agreed,
Sorry.
that's
Any
where
matter
it's
that
referenced.
falls to be considered by the board.
Yeah, that's
All
where it's
right.
referenced.
Yeah.
Minister, Chair, in looking at it, the proposal was also to add the language at Regulation 888. That's the education regulations. It specifically indicate, even though it has the matter of the member recusing him or herself, it says no member shall vote on any question in which he has a direct personal interest. So I think they wanted to expressly state it's the education regulations. So even though it indicates that the person shall withdraw from the meeting if they have a interest in the matter, it also expressly stated that they shall have no vote.
So,
So I think
Council,
that's what.
should that be the new 12.5 or 10.5? It says new 10.5 in the matrix. Should it be 12?
Chair,
Yes, go ahead.
based on what Anastasia just said, 12.1b says that they must not take part in any deliberation or decision. That would cover voting.
Right.
They
That
won't
was
be
the
able to.
discussion we had, but they said that they wanted it to be expressly stated that
It
they
is
shall
expressly
not vote.
stated in 12.1b.
They wanted to say shall not vote.
The opening words of 12.1 says shall not, and B said take part in any deliberation or decision on the board with respect to the matter if the board decides that the interest in question shall affect prejudicially the members' consideration of the matter.
Yeah, but let's be very clear on this. Because the mere fact that you recuse yourself, it absolves you from voting. You can't vote. You're out of the room. So how you going to vote?
By proxy.
No, man.
So are we all agreed with the language that's currently there in 12.1, well, all of 12.1? Members?
I'm comfortable with the existing language.
Okay. Members? All right. We affirm that. All right, let's move on to the second schedule.
Chair?
Yes?
Two things to note in terms under paragraph 10, procedure at meetings and meetings. At 10.1, instead of saying at such times as may be necessary or expedient, there was a proposal to indicate at least once every 2 months, that they shall meet at least once every 2 months, instead of saying at such times. 10.1 says the board shall meet at such times as may be necessary or expedient for the transaction of business at such places and on such days and utilizing such modalities as the board may determine. The proposal is to change at such times as may be necessary or expedient to at least once every 2 months. So it's indicating an at least time.
Could we say the board shall meet at least once every 2 months or as may be necessary or expedient?
But if it says at least, the at least would cater for if you want to meet more than the 2 times, the one time.
Agreed.
So moved. All right.
Chair, in terms of quorum,
Uh-huh.
based on the increase in the Constitution, the quorum is currently 7. So a third would put the odd number to 9.
So we agree quorum to move to 9, given the change in numbers from 23 to 29. Okay. Council? Okay, all right, we agree. Members, so moved? All right. Second schedule. All right, you'll note,
Sorry, maybe I missed it when I was absent last week, but on page 66, which is in the first schedule, I have a note here from 2 meetings ago where we said the support team would provide suggestion as to makeup of this committee in 14.2b. Was that done already? Sorry?
That's in relation to the composition of the Professional Practice and Conduct Committee.
Yes.
Those instructions are still being worked out for the Office of the Parliamentary Council.
Okay, thank you.
Schedule 2, new definition of teacher support services to be inserted under clause 2. Word should be teaching and not teacher. And to be removed from the definition of teach, as they are not teaching activities. Can you explain a little bit more? Second schedule, page 67.
The teaching support services, Chair, Minister. It says the teaching support services.
All right, so from the JTA, it says the second schedule, part 10, but I don't see part 10, deals solely with teacher support services. However, no reference of the service is made in the sections of the bill, despite the schedule saying it's mentioned in sections 2 and 76 of the bill. Right? It says section 2 and 76. Inclusion of these services would be quite useful in improving the personal and professional lives of teachers, and the JTA recommends that this be rectified. It's odd that we just have this listing.
Madam Chair, if I may seek to clarify, the mention of the services are under the definition of teach. So if we look at clause 2, and there was an indication at B under the definition of teach, to say does not include duties of the kind undertaken by a person who provides a service specified in the second schedule which supports the delivery of the duties under paragraph A1 or 2. Okay. The reference to the services is mentioned in the definition of teach to indicate that these persons who provide coaching services, services having to do with lab work and so in schools, these persons would not be considered teachers or to be considered to be teaching. So when we were discussing the amendments to teach, we sought to make that clear. That is where this specification comes from. Right, because that was an amendment that was proposed when we were discussing. So,
where exactly we insert that amendment?
okay,
Just for the flow.
right. So perhaps I should read the entire definition of teach. So teach means to undertake duties in any educational setting to which this act applies that A, include 1, the delivery of an education program designed to implement or supplement a curriculum or syllabus, and the assessment of student participation in the education program, or 2, the administration of an education program. B, but does not include duties of the kind undertaken by 1, a teacher's aide or a teacher's assistant in the care of students or the supervision of their work under the direction of a licensed teacher or a person who has been granted an authorization to teach under this act. 2, a student enrolled in a teacher preparation course on practicum placement as part of that course. 3, a person employed or engaged to provide care at an early childhood institution, but who is not employed or engaged to teach at that institution. And this is a new 4. A person who provides a service specified in the second schedule which supports the delivery of the duties under paragraph A1 or 2, and 5, such persons or in such circumstances as may be prescribed.
Where I'm connecting the dots now with the listing in the first schedule. Take, for example, lab services. You have lab techs. Technology services, the IT persons. Career services, those are persons who support things like career day, the development. Behavioral services now, is this your guidance counselors? All right. And the health services must be a nurse. Okay. So these are not, they might support education, and so they offer these support services, but they are not there as defined teachers or practicing teachers. All right.
And Chair?
When I went I get it, but that's why I'm wondering about the wording, Madam Chair. I'm a little bit cautious. Because when I was in high school donkey years ago, we know, and maybe things have changed, the guidance counselor and the nurse actually taught sessions. They were on the timetable as teaching sessions. So maybe in new times, they don't come and teach any sessions anymore. No, I was after the donkey riding. But so is it that that's no longer, there are no schools with a session called guidance and counseling anymore?
No, there are sessions for guidance and counseling, but the guidance counselors now, they can pursue a program that's not a teaching program. The long ago days, guidance counseling was done in the teachers' college and a teaching program. But today, counselors are appointed and they are counselors, they're not teachers. So while they have counseling sessions, they are regarded as counselors. They're not classified as teachers.
And under the technology services?
The technology services, they were never classified as teachers.
No, I'm just looking at, so the person who, again, when I went to high school long ago, the technology person in the computer lab, because yes, Senator Gale, they had computers when I went. The person in the computer lab they would sometimes teach. Is it that we're saying the persons who now work in the computer labs in schools, and again, things may have changed, they can't teach?
No,
Because
no.
not all schools employ an IT teacher, especially at the primary level. The primary schools with labs don't necessarily have an IT teacher.
But that person could be authorized to teach, so that is not a, that's not a challenge. The person can be authorized to teach.
So they could be authorized to teach?
Yes.
Okay.
But I hasten to say that we still have colleges that have guidance counseling as part of the training program. I don't know that it's widespread now that we have a degree. We have colleges granting degrees in guidance counseling. And then we have the deans of discipline, and they're not teachers.
Chair, the mere fact that you would have asked to make the connection in the first schedule, you have a list here, but there's nothing that connects the list, save and except it says second schedule. Could we just tidy it up? It look a little naked to me. Is there any preface, anything that can just connect it to what it would be referring to? Because all we're seeing is just a list of services.
Madam Chair, through you, please. This would require further instructions from the ministry if you want a more substantive provision in the bill to talk about these services so that persons would get a better understanding of what it means to be involved in behavioral services, providing behavioral services to a school, for example. So then you would be able to put more meat on the bones. But that would... Yes, because they would have the information about these services for us to craft a fulsome provision. Because you're saying, because it's simply mentioned in the definition section, it is not sufficient. You want some more information about these services.
I didn't understand Senator Gale, and he can speak for himself. But I was agreeing with him on the grounds, not that I was looking for an explanation of the services. I was looking for an introductory paragraph or a sentence to tie it back so that if someone just looked at the schedule, they'll know what it relates to. Because at the top it says Section 2 and 76. But 76 has, I can't find anything in 76 that relates to it.
I believe 76 is merely saying that the minister may by order amend the schedule to include other services.
Okay. But just an introductory line or something that ties it back to the definition, I think that's what, I was looking for an explanation of the 5 things. I was looking for something where if you look at the schedule, you knew what it related to.
It's just direction here. All right. I think the legal team can tidy this up a little bit, all right, in terms of the references.
So the reference would normally be what's in the bracket in relation to the schedule. So you would have to go to
Section
see
2 and 76.
what it provides.
Okay.
And just to note, Chair, for the committee, that is, those 76 are actually supposed to be referenced as 75 and not 76.
Section 2 and 76, it should be 75? Section 2?
Right.
75? Okay.
75 currently speaks to the amendment of the different schedules. But maybe 75, 76 in yours? Right, so it's supposed to say that the minister by order, 75 reads, the minister by order, may by order, subject to affirmative resolution, amend, and 75B says the first, second, third, fourth, and fifth schedules. So it should be 75 and not 76. But I'm not sure based on the new inserts, and so if there is going to be a shift in number, but we will.
No, but what I'm hearing is just, I don't know, an introductory few lines. Not sure. But if that's how it's to be represented, if that's how it, then Member Rodriguez? Yeah.
And Chair, in terms of the teaching support services, there was a proposal to add social services and coaching services under the listing.
We agree, members? Coaching. Okay. All right, let's move on to page 36 on the matrix. Clause 10 on page 71 of the third schedule, where it speaks to protection of officers and employees of the council and members of the board. So the recommendation from the University of the West Indies is that in the third schedule, part 10, the following were stated. Stakeholders considered that the words in or omission made in good faith in the course of carrying out the provision of this act might lead to prejudicial interpretation. Regarding the composition of the council board, many teachers have been recommended for appointment to the board. Stakeholders consider that it is imperative to consider the insertion of the following clause. Any member of the board must recuse/withdraw himself or herself from the case if they have any relations or personal knowledge of the teacher whose case is being dealt with. Okay. I didn't understand their comment that on page 71, clause 10, that it's prejudicial. You can help us with that, counsel? It might lead to prejudicial interpretation.
Minister, I think they are alluding to paragraph 10 under the third schedule. It says no suit or other proceedings may be brought or instituted personally against any officer or employee of the council or any member of the board or any of the committees of the board in respect of any lawful act done or omission made in good faith in the course of carrying out the provisions of this act. So this provision, it's basically protecting an employee who is acting in good faith on behalf of the employer. So I'm not sure why the UII thinks that it would be a prejudicial, it could be a prejudicial interpretation.
What I'm understanding this clause to be doing is that whilst you're acting as a member of the council, it would be seeking to validate any action whilst in the course of your duties as a council member. Now, I don't see that as being prejudicial in nature because you have a fundamental role to play whilst you're a member of the council. And what this is seeking is to somewhat insulate or protect you whilst you're a member of the council. So I don't see it being prejudicial. It's not that it is protecting you from anything outside of carrying out your duties as a member of the council. And I really believe if you are given this opportunity to be appointed and to carry out such duties, it ought to come with some level of validation.
I think we agree. We all agree with that, members. All right. So we just have a few more points in the fourth and fifth schedule. In the fourth schedule, Teachers Association recommendation is that the fitness to teach requirements, as outlined in the fourth schedule, part 1, They're saying that it can potentially be in conflict with the Disabilities Act. Fitness to teach is considered for all applications before the council, and a part of determining factors of fitness is consideration to physical, mental incapacity or illness, while the bill focuses on illness or incapacities that will or is likely to interfere with the practice of teaching. The council must be cognizant of the Disabilities Act, specifically sections 24.3 and 25.4. What do we say?
I think the legal people need to tell us whether or not it is compatible with the Disabilities Act, and if it isn't, just fix it so that it is compatible.
But I see in my notes here, I don't know if I'm wrong, that the team has said that they will insert a proviso at 1E to state a language that indicate that provided that any action does not violate the Disabilities Act. I think that's something from you. It's here on page 37 of my document.
Right, but that one is from the Teachers Colleges of Jamaica. I don't know if it's the
No,
same
I'm talking
thing,
about
so.
the response from Mrs. Gordon Jones et al. That thing that says collective response, I think is their response to it saying. Am I correct in
response to
Is
all
that
of these?
response in relation
to all of these?
what
to
would
the
have mentioned in
Disabilities Act?
24.3 and 24.4 under JTA?
Looks like the JTA, Teachers Colleges of Jamaica and University of the West Indies, has some concern. Either way. Okay, yeah. All right. So there will be language to indicate that provided that any report/action does not violate the Disabilities Act. All right. We'll take that.
Sorry, Minister, I wish the language not be negative, but it must accord with, I think we should state it positive, that such approach must be in accordance with the Disability Act. So state it positively rather than in a negative.
Duly noted, member. All right. Yes, it will. The technical people are indicating that they will draft it that way. All right, and we move on to the last schedule, fifth schedule. What is the point? What is the point? Okay. No, I thought the response was a collective response because they had the same. UWI said in the fourth schedule in Part 1C2, it is recommended that issues of biological/non-biological determinants be specific, and that the term "his" concerning members of the teaching profession be clarified. Okay.
Madam Chair, I support that point because it should be gender neutral. It should not be his registration. No, in 2023, we should not be using his registration. It should, it has to be gender neutral.
This is the Women's Caucus.
Yes, it cannot be his registration.
Is the
It's
member
on page
repealing
72
the
on the
Interpretation
C2,
Act?
1C2.
Is the member repealing the Interpretation Act?
Senator Brown, I see the smile on your face. Keep that camera on so that we can see the smile on your face, because you know it is correct. We can't have a gender-based pronoun being used here, because there are female teachers as well.
Senator Camp,
and the majority of teachers are female.
Over and over in respect to legislation. There's no smile now on my face, right? Yeah, there's one.
It is.
I've raised it over and over. But we're subject to the Interpretation Act, which says the masculine mean the feminine and the feminine mean the masculine. Until we make those changes.
But it doesn't. What prevents us from doing the right thing now? Because I've seen in other acts. that I've seen, it's not as though we're violating another piece of legislation. We are not. Because nothing in the Interpretation Act says we can't be gender neutral. What it says is we should interpret the genders a particular way, the gender language. But my understanding, it doesn't say we can't do the right thing. And
I'm
so,
not going to engage in a debate. I'm
and
just simply
so
saying
we shouldn't be using
I understand the Interpretation Act to allow for such wording. You could change it to her too.
No, we're not asking it for her.
Right?
We're asking for it to be neutral. The legislation, the interpretation says you can interpret masculine to incorporate everything. It doesn't say you can't be neutral.
Since I'm not going to get into a debate on the issue, I just put my views, I don't. It's a committee decision.
Thank you. Madam Chair, can we ask the legal team to clarify my interpretation of the Interpretation Act? My interpretation is that you can use masculine pronouns and it is acceptable as considered as being referring to females, but it does not prevent you from doing the correct thing and being gender neutral. Am I correct? And if I'm correct, Madam?
You're correct, member. There's no harm in saying her.
No, I don't need it to be her. I need it to be neutral.
No, what I'm saying, his or her.
Right.
So we can say his or her.
Thank you.
Right.
Thank you. And the committee?
I'm in agreement.
So moved.
So moved.
All right.
But the drafter, sorry, Chair.
And are the drafters going to do that for everywhere?
Yes.
What happened?
Yes, 2023.
Gender neutral language is what it is very clumsy with a constant his, her. Please, Mrs. Sherlon, the gender neutral approach is the one which the bills that I'm seeing is using. Why are we departing from that?
Thank you.
Madam Chair, normally we try to stay away from the pronouns and we say a person. But it's not in every circumstance that it's appropriate to use a person. And so if the committee insists we can use his or her,
in this instance, can't it be shall take into account whether the person's registration as a teacher or license? So you'd put the "they," you'd end at "they."
And we like to stay away from the apostrophe. So we could try and use person.
Yes, please.
All right. So noted. We'll move to the fifth schedule. We have two comments. The first is from the Ecumenical Education Committee and the Jamaica Council of Churches. Recommendation in the fifth schedule. The fifth schedule is the constitution of the tribunal. The fifth schedule, it is being proposed that the appeals tribunal be comprised of the following persons: a retired judge, a representative of a professional teachers association, and a representative of the owners of denominational and trust school. And the response is status quo to remain regarding constitution of the tribunal. Why status quo? Members, could you take a look at it? We're going to end at about 12:45, so let's just consider these last two. So currently the appeals tribunal consists of 3 members: chairman, who is a retired judge of a superior court of record, a retired teacher, and a representative of Professional Teachers Association. That's not the status quo currently.
I think there would have been subsequent discussions after this response was provided. So, because I'm also seeing on my notation on my bill that the word professional is supposed to be removed from 11C. I am not sure if Mrs. Sherland has.
Madam Chair, like some other parts of this bill, this has gone through a lot of discussions. But looking at what's happening now with the tribunal, I think we need an attorney at law on the tribunal. The judge, the attorney at law, and the representative of the Jamaica Teachers Association, or the body that represents teachers, not JTA.
The judge would be an attorney. So why do we need two attorneys on it? The judge, by first fact that he was a judge, is an attorney. So we already have that legal representation there.
I think there should be a representative of a parent association.
Yes, that's good.
Yes. Members? A representative of a parent association. No, I'm saying I'm proposing a representative of the parent association.
Madam Chair, I agree with the parent.
On the tribunal?
Yes, on the tribunal, a representative of the parenting association. I support your suggestion, Madam Chair.
Would that be 4 or 3? Because who are we leaving off?
I ask a question just for my own understanding. We have a representative of the Teachers Association who is a registered teacher.
Yes.
Why do, and I understand that, and I understand the purpose of the judge. I just want clarity on why a retired teacher. Since you have a teacher that's currently in the classroom, why are we putting a retired teacher?
The retired teacher from the association, the body that represents teachers?
No, the association is not the retired. The association is the current teacher, but it has a retired teacher.
All right. The purpose of the retired teacher, and it's traditional, is that that person has the time for the tribunal, which is why the retired teacher has been on the tribunal.
Oh, so could then the parent, if it's a matter of time, could it be a parent? Because that's a stakeholder that's not representative, a very important stakeholder. And the chairperson has recommended a parent. And I think if we're looking, all parents make time.
We have changed over time. The present tribunal now, the chairman is a retired judge, and it works beautifully. There's need for a lawyer because of the amount of investigation and work that is done in any case. We have also had to recruit an additional lawyer to help that lawyer in the tribunal, and the person from the Jamaica Teachers, the Professional Association. So those are the people on the tribunal for the last couple of years, and it works.
Right, but I'm just asking, is there a fundamental, other than tradition and the way we have always done it, is there a reason we cannot have a parent replacing the retired teacher? Because we got...
No, it's a teacher's tribunal, and the issues are about teachers.
So then should we add the parent?
Doctors don't have patients on their tribunal. The lawyers don't have anybody but lawyers on the tribunal.
But it's a different scenario. Parents are a major stakeholders within the education sector.
Look, if we are going to look at stakeholders in any profession, then we are all stakeholders in the hospitals.
So are you saying no to a parent representative? In your opinion, we should not have a parent from the Parents Association on the tribunal?
Not in issues concerning teachers' misconduct and professional conduct, because most of what comes before a tribunal is a teacher's professional practice.
So your answer is no, you would not support that?
I find it difficult.
Mr. Gordon, most of what comes in front of the tribunal has to do with children. Huh?
There something in the law to prevent it? Because most of what teachers go before a tribunal for relate to children. No, madam. I would stand to disagree with you because, as I said, teachers deal with children who are vulnerable parts of society, very vulnerable. We have to always bring it back to that. So unless there is something in the law, Madam Chair, I would like to support the idea that the tribunal should include someone from the Parents Association. Yes, the National Parent Teachers Association. I would like to support, if we need to add a member, we add a member, but I would really support that idea, Madam Chair.
You know, if we look at the history of the issues that come before the tribunal, it's rarely, in fact, it probably happened once in my 12 years, that the matter before the tribunal is a matter that is related to a child. It's usually professional conduct and behavior at the adult level. And if there is malpractice,
Dr. Gordon.
there's malpractice, then there's malpractice that the teacher doesn't come to work on time or the teacher does not prepare the plans and so on. That is not something that a parent can assess a teacher on. You know, it's a teaching council and it's a teacher tribunal, and in all the other professions, teachers are managed by the professions manage the professional.
Dr. Gordon, I know that I've been only looking at the issues of the appeals tribunal within the last couple of years, but the cases that I have seen involve students, some altercation, something with students. Even this last one that was published in the paper as well had to do with a gun and a student. And so members, composition of the appeals tribunal. The chairman of the tribunal shall be a retired judge or a superior court of record, a representative from the Teachers Association, recognized by the minister, nominated by the association, and we could increase the number, but I would like to see a representative of the National Parent Teachers Association on the tribunal.
Minister, can we sleep on this one and come back to it? Because are we going to go to a 5-member appeal tribunal? Is this going to be a permanent, I mean, a everyday tribunal, such as, say, the IDT? Can we sleep on it, given the time? It's 12:46, I believe. And so with that, a few matters we have to do. We add this one to that list for the next meeting. That will be my proposal, because I don't want to be rushed into changing what has been there before.
All right, we can sleep on it, but let me just finish the next recommendation, because that's the last item on the matrix. And this recommendation comes from the University of the West Indies School of Education. In the 5th schedule in part 1.2, this exception was considered a prescription for abuse and builds in a permissible departure from due process. Thus, a minister could appoint a tribunal departing from the provisions to secure an outcome in relation to a teacher whose matter is expected to be heard. Good legislative practice suggests that prescribed procedures be observed. Somebody could explain that to me. I don't have the historical context here. This is suggesting that these tribunals are pop-up tribunals. They're not. They're appointed for a period of time, and that's it. All right. Was there a discussion to come back to us? All right. We will sleep on the issue of the tribunal and come back. For our next meeting, we'll have some carryover matters, and we'll have the second schedule. This has to do with the homeschool. I'm going to ask members to look at this because these might have already been addressed. Part 2 of the matrix for the next meeting. I'm just saying, please read before you come to the meeting because the matters here may have already been addressed in all our deliberations. All right. So members, considering the time we have to end, are there any other business?
Madam Chair, if I may.
Please go ahead.
Yes, I might be out and I missed the point, but I just wanted to drag our memories back to the 4 members from the universities. Is that we're just going to outline the names of the institution or just 4 persons from a universe that offers teachers education?
I think we were going to specify UWI and UTech.
I think we can think about that some more, Madam Chair. I don't think it would be wise for us to do that in just outlining 2 persons. It might create some issues in the long term.
Okay, member.
My thoughts.
All right, thank you. Next meeting dates, Thursday, February 16, 2023 at 10 a.m. Thursday, February 23rd, 2023 at 10 a.m. Members, I would love for us not to go beyond February. Right, yeah. All right. 16 and 23rd at 10. And so, yeah, we need to conclude on this because there's a report that needs to be written and so on, and tidying up. February 16 at 10 a.m. and the 23rd at 10 a.m.
Could I inquire if there's a date set for the proroguing of the Parliament and resumption?
February 14th.
February 14th for the resumption. Lamy. That's the opening, for the opening.
Yeah, so we need to, I don't know, there's going to be some need for the appropriate continuation resolution, but sufficient to the time, I think.
All right, we're going to have to look at these dates again, Mr. Nash, because there looks like there's a conflict on February 16th. See if we have any other dates other than Thursday, February 16th. All right, let's look at another date and send it out. All right. Conclude the meeting. So meeting is adjourned. What? Is there something else? We're going to just review the schedule for Parliament to see if there's another date that we could use, and we'll send it out today so that you can put it in your calendars. All right? All right. Meeting is adjourned. Thank you so much.
Reggae Month TV, on air, on cable, online.
Whoa, 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 yeah, I'm Mr. Reggae Ambassador. Whoa, 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 yeah, I'm Mr. Reggae Ambassador. Hey.
You can walk your country walk, walk Caribbean walk, walk the African walk, walk the American walk, walk the Brazil walk. You can walk.
Winston Rodney, aka Burning Spear, has been a missionary of reggae music for over 35 years. With every record release and stage performance, he conquers hearts and minds across continents.
Where it's back a wire, he's nowhere around. He can't be found. Press the trail who gave away Marcus Garvey, son of Satan. First practices.
The tale of the start of Burning Spear's reggae movement involves Marcus Garvey and Bob Marley. The two men who share Rodney's birthplace of St. Anne influenced his life and his music. Garvey's philosophy guided his beliefs, and this is reflected in his lyrics. And it's said that Bob Marley arranged for him to meet music producer Coxsone Dodd.
Sipping from the cup of peace, which hand down on bar.
Rodney took Marley's advice, and around 1969, he and his singing partner Rupert Willington auditioned 3 songs for Dodd. Dodd selected the song Door Peep as the duo's first single. By this time, Rodney had named the group Burning Spear, the nickname of Jomo Kenyatta, who was jailed by a colonial British government in Africa but rose to become the first president of Kenya. Soon after the release of Door Peep, Delroy Hines, brother of Carrigo Bring Come Home singer Justin Hines, joined the group. Burning Spear, now a trio, released a series of singles on Studio One, including the 1972 Jamaican smash, He Prayed. The next year, the public received the group's debut album, Studio One Presents Burning Spear, which was followed by another hard-hitting album, Rocking Time.
But you must know the time, children.
The trio continued to put out more singles, but a hit like He Prayed seemed intangible. In 1975, Burning Spear and Dodd parted ways. The group then joined forces with producer Jack Ruby. Their initial sessions produced immediate hits like Marcus Garvey, an exclusive track for Ruby's Ocherius-based high-power sound system, which was eventually released as a single by popular demand. The follow-up single, Slavery Days, further proved Burning Spear was no one-hit wonder. The group, accompanied by the Black Disciples, a phenomenal studio band, worked with Ruby on their third album, Marcus Garvey, released in 1976. After the album became a hit in Jamaica, Island Records stepped in and signed Burning Spear. However, they immediately outraged the trio by remixing their songs for white consumption. An equally light dub mix, Garvey's Ghost, was a weak attempt at a peace offering and did little to soothe Rodney's fury. To ensure that he maintained control in the future, the singer established his own label, Spear, debuting it with the single Traveling of the old Studio One track, Journey.
We've been traveling, for we've been traveling more than 2,000 miles.
Despite having its own label, the group's next album, Man in the Hills, was also released on Island Records. The compilation featured an impressive new version of the group's debut release, Door Peep, and the stunning club hit, The Lion. Late 1976, Rodney decided to continue his musical journey without producer Jack Ruby and group members Willington and Hines. From that moment onwards, the name Burning Spear represented a solo artist. Shortly after, he released the self-produced album Dry and Heavy, a live album from a show done at London's Rainbow Theatre, and the 1978 release Social Living, which featured the reggae anthem Civilized Reggae. 1979 was an outstanding year for Burning Spear's solo career. He performed for the first time at Reggae Sunsplash and he starred a leading role in the film Rockers. His a cappella performance of Jano Dead is one of the film's most memorable scenes.
And they tried to fool the black population by telling them that Jaja did. High and I knows God, Jano did.
The following year marked the end of his contract with Island Records, and in 1982, Rodney inked a deal with a Heartbeat label in the US and recorded his debut album for them, Far Over. The album showcased Spear in a different light. It was still a roots album, but Spear was exploring non-cultural themes, as heard on the popular track, She's Mine.
Oh, Gilo, Gilo. Can't mess with G. Can't mess with G. Yes, the fittest of the fittest of the fittest of the fittest.
Spear continued to explore new themes on the album Fittest of the Fittest. Burning Spear's final album for Heartbeat label was the Grammy-nominated Resistance. His next album, People of the World, for the Heartbeat label in the US, also got a Grammy nod. Its follow-up, 1988's Mistress Music, suffered from poor production. But better was the Live in Paris Zenith album, recorded at a show in May and released the same year.
When we reach the clock, holding our songs, singing happy songs, side by side.
At the beginning of the 90s, Spear returned to Island Records. By this time, he was already recording the kind of music the label wanted, as heard on the album Mek We Do It. After the release of his Jack King album, Spear returned once again to the Heartbeat label to release the Grammy-nominated World Should Know and Love and Peace Live 1994. The live album features some of Rodney's most inspirational singles. It was believed Spear delivered his best work on stage. For the rest of the 90s, Burning Spear continued to tour the world. He released 2 more Grammy-nominated albums, Rasta Business and Appointment with His Majesty. He finally won a Grammy trophy in 2000 for his album Calling Rastafari.
Rastafari, sons and daughters of His Majesty.
Following his Grammy win, Spear embarked on an American tour to promote the album Calling Rastafari. In 2003, he launched the Burning Spear Records label and released the albums Freemason, followed by Our Music in 2005. Burning Spear's devotion to his music continued well into the 21st century. In 2009, his Jah Is Real album earned him another Grammy trophy. He showed the world his music, 40 years later, was still of the highest quality.
That's why they will try to take over. I'm Mr. Reggae Ambassador. Whoa, 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 yeah. I'm Mr. Reggae Ambassador. Hey.
Remember, gambling is just a game. Choose to gamble responsibly. Set a budget, avoid chasing losses, and stop gambling when you reach your money limit. For gambling help, call RISE 888-991-4146. A message from the Betting, Gaming and Lotteries Commission.
Reggae Month is February. February is Reggae Month. Go catch the rhythm on Reggae Month TV, 8 p.m. to 11 p.m. daily in February. Catch the mega reggae concerts, interesting reggae documentaries and symposia, reggae conversations with pioneers of the music, and lots more. Reggae Month TV all days in February, 8 p.m. to 11 p.m. on PBCJ and the Ministry of Culture social media pages. Get all the details real time on the Reggae Jamaica mobile app and come catch the rhythm this Reggae Month.
Matza for me, matza for you, that. Look how hard me I work, oh God. Now feel much me work so hard. Confident out there now, one straight edge now. Matz in my world, my world.
Hello students, I am Mrs. Hazel McNeil Darby. Today's session is about indices. By the end of the session, you should be able to state the meaning of A raised to the power of M, where A and M are whole numbers. You should also be able to evaluate expressions of the form A raised to the power of M multiplied by B raised to the power of N, where A, B, M, and N are all whole numbers. You will need your notebook, a pen or pencil, and a calculator if you have one. Let us begin the session. We will start with some key phrases, meanings, how they are used, before beginning the exploration of indices. A number written in index form is that number written as an exponential expression or a single number raised to another number. For example, 5 raised to the 4th power, or some say 5 to the power of 4. There are 2 component parts to a number written in index form. There's 1, the base number, and 2, the index number, also called power or exponent. A number written in the form a raised to the power of m is said to be written in index form. In the exponential expression shown, the base number is a, and it tells the number that is to be used as a factor, or as we say, multiplied by itself. The indexed, also called the power or exponent, m, tells how many times the base number is used as a factor. Or to say it another way, how many times multiplication is to be repeated. Here are some examples. As we go along, listen and make note of how the opposite pair of words expand and simplified are related and are used. The first example is b to the 5th power. This means b is used as a factor 5 times, or said another way, b is multiplied by itself 5 times. So, when expanded, we get b times b times b times b times b. Example 2 is 4 to the power of 3. This means 4 is a factor 3 times, and written in expanded form, we get 4 times 4 times 4. This can be simplified to give 16 times 4, and that is equal to 64. The last example is 5 to the power of m, or simply 5 to the m. This means that 5 is a factor m number of times, or said another way, 5 is multiplied by itself m number of times. M here is a variable, not a specific number, so we are unable to state the exact expansion like we did with the previous examples. Now here's a challenge for you to find happy numbers. Today we'll only search for those numbers less than 30. Here are the instructions. Pick a number less than 30, square each digit, and then add the results together. Use the new number and do the same again and again. Square each digit and then add the results together. If you reach 1, you have a happy number. I'll pause for you to do that. Well done. How many happy numbers did you find that are less than 30? Here is the complete set of all 7 of them. 1, 7, 10, 13, 19, 23, and 28. I will now follow the instructions using 23. Square 2 and 3, and then add the results. This would be 4 plus 9, which is 13. Now use 13. Do the same again with the 13 this time. Square 1, square 3, and then adding, we get 1 plus 9, and that is 10. Now use 10. Again, squaring 1 and 0, and then adding, we get 1 plus 0, and that is 1. The chain is 23, 13, then 10, and finally 1. Therefore, 23 is a happy number. Let us review what we know so far about indices. I have some questions. First, what does a number written in index form look like? Yes, it's written in the form a to the power m. Next, what are the main component parts of a number written in index form? Well done. The two components are a base number and an indexed number. Remember, the index is also called the power or exponent. Let us look at the number 6 squared, a number written in index form. What is the base and what is the indexed? Correct. The base is 6 and the index is 2. Now, write 6 squared in expanded form. Very good. 6 is a factor 2 times, or 6 times 6. When simplified, what is the result of 6 squared? Good job. The single number is 36. Moving on. We will now investigate to discover what is commonly known as the product law of indices. As we investigate, I want you to look for and make written notes on any pattern that you see. Now let us start with the first one shown on your screen. We are looking at 2 squared times 2 to the third power. When expanded, 2 squared is 2 times 2. 2 to the third power is 2 times 2 times 2. This is indeed 2 as a factor, a total of 5 times, or written in index form, 2 to the 5th power. Now let us examine the second example. Okay, it starts with 3 to the third power, then that is multiplied by 3 to the first power. Expanded, we get 3 times 3 times 3 times 3. So now 3 is a factor 4 times in all. The result is therefore 3 raised to the power 4. I will now allow some time for you to complete the other 2 questions. Ready? Let us start with part C. Expanded, it is 6 as a factor 2 times, multiplied by 6 as a factor 3 more times. This is simply 6 to the 5th power. Part D is expanded so that A is a factor 3 times, then 4 more times. A total of 7 times in all. So we write A to the 7th power. From the investigation, you should have discovered what is commonly known as the product law of indices. So now let us see if we can state that law by completing the following sentence. Read the sentence, fill in the blanks. Good. The complete sentence should read, to multiply numbers with the same base, keep the base, and add the indices. As a general rule, good job. As a general rule, therefore, the mathematical sentence, as shown on your screen, a raised to the power m times a raised to the power n equal a to the m plus n. Remember that the base must be the same for the rule to work, or you are not following the rule. That's a fact. Let us look at using a calculator to evaluate a number written in index form. This would be a scientific calculator, not just an adding machine. You need to identify the calculator key with a base and an index. Let us call it the exponential key. It may look like y raised to the power x or some other symbol in the index position. With the calculator that you're seeing here, that key will be uncovered now. It's in purple. You see what it looks like? It may not be in that position on your calculator, but you must know what you're looking for, what it looks like. Let us use a calculator. So, for example, to evaluate 4 raised to the power 5, enter the base number, it's highlighted on the calculator. Next, press the power key, it's highlighted there in pink, and then enter the index number, which is highlighted as well. Finally, press the equal sign to get your answer. There it is at the top of the calculator, 1024. Let us go over and make note of some of the calculator keys to use to find the value of numbers written in index form. Take a picture so that you will have it. First, enter the base number. Second, press the exponential key. Third, enter the index number. And fourth and last, press the equal sign. Now it's your turn. Try using the same base and index number. So that would be
4 raised to the power 5.
Did you get the answer? Good job. All right, here's a table. Use your calculator to help you complete the table. You are to fill in values in the highlighted second and last columns using the given expression in the row. I will give you some time to work. Did you notice a pattern with the values as you were working? Oh, yes. Let us have a closer look at these rows. I will first record the values. First row, the value is 1024. Going across, 1024. Next row, with 3 as the base number, the numerical value is 6,561. And again, 6,561. The last row, the value is 512. So, looking at row 2 again. The numerical value in the second column, we're working on the second column, is the same as the numerical value in the last column, 6,561. Here's a thought. This time we are going to look at the first and third columns. The expressions column. There's a pattern that explains the connection of the two expressions in any given row. Describe the pattern. Take some time and make note in your book. You are correct if you stated the product law of indices. For example, using row 1 this time with 4 as a base, the indices are 2 and 3, so 4 is being multiplied by itself 5 times in all. Or to use the product law for indices, the base is 4 each time, the indices 2 and 3 added gives 5, the same number as the index in the third column, 5. When the expression in the first column is simplified, we get the expression in the third column. Well done. Now it's time for us to review what we have learned so far. First, write a to the third power in expanded form. Well done. It is a times a times a. Next question. What does 7 raised to the power 3 means? You are correct if you thought of 7 times 7 times 7, or 7 as a factor 3 times. Now, use your calculator to find the numerical value. In other words, simplify or evaluate. Using the given index form, 7 raised to the power 3, or the expanded form. Okay, as expected, each one gives the same answer, 343. Okay, now try this one. It comes with a warning. Here's another challenge for you. Simplify, and that means write using indices. 4 times 4 times B times C times C times C.